Saskatchewan Marriage Commissioner Larry Bjerland doesn't take kindly to threats.
I see a red flag when I hear the word "or else." My mother used to do that, you know? But she had the right.
In 2004, when the government of Saskatchewan sent him a letter stating he had to perform same-sex marriages, he spoke up.
There comes a time when you have to stand up on your hind legs and be counted.
Though commissioners are public employees, Bjerland objected because of his faith. And he wasn't alone. In fact, the letter was the first shot in what's become a battle for religious freedom.
I think it essentially starts with a letter that was sent November 1st, 2004 to all the marriage commissioners in the province of Saskatchewan.
Faye Sonier is legal counsel with the Evangelical Fellowship of Canada, a Christian association engaged in law and public policy.
What it included was essentially a notice to the marriage commissioners that if a ruling to be released within the next few days came back as stating that same-sex marriage was legal in that province, marriage commissioners would be required to perform those marriages or lose their licenses.
In the past, many of the marriage commissioners, though refusing to perform same-sex ceremonies, referred couples to commissioners who would. 4 days after the letter was sent out, same-sex marriage became legal in Saskatchewan.
And from that flowed a number of lawsuits, human rights complaints. A few marriage commissioners filed a suit against the province on the grounds of discrimination for violation of their religious beliefs.
Despite the ruling, several marriage commissioners stated publicly that they would not perform same-sex marriages because of their religious beliefs. Bruce Goertzen was one of them.
And I thought to myself after prayer that maybe this is my time. This is my time to stand up and say, the government of Saskatchewan has gone too far. I need to say this is wrong. And if I get fired, I get fired.
To try and accommodate commissioners, the government of Saskatchewan took themselves to court.
Well, what they did,
Faye Sonier.
The Minister of Justice asked the Saskatchewan Court of Appeal for an opinion. So it's a reference, a legal reference. And what he did is he introduced two types of potential legislation to be added to their Marriage Act.
The first option would allow all commissioners to decline performing same-sex marriages on the grounds of religious beliefs. The second excused only those commissioners who held office when gay marriage was legalized in November 2004.
We were very concerned that marriage commissioners, in particular with religious beliefs, would have the right to recuse themselves from performing marriages that were contrary to those religious beliefs.
The Evangelical Fellowship of Canada, along with other Christian groups, intervened, arguing for accommodation.
We have a long history of case law which recognizes the importance of religious freedom. We also discussed in the courtroom in particular that our country is a pluralistic society and our public square, our public space, is one that is religiously inclusive.
In January, the Saskatchewan Court of Appeal rejected both proposed options, stating they were unconstitutional.
Well, they found that the proposed amendments were too broad, and they found that though a refusal to accommodate marriage commissioners' religious beliefs would result in a violation of marriage commissioners' charter rights and freedoms, Section 2A, which is the right to religious freedom, it was necessary in order to protect the equality of rights of gays and lesbians in Saskatchewan.
In his 43-page decision, Justice Robert Richards said, quote, "Persons who voluntarily choose to assume an office like that of marriage commissioner cannot expect to directly shape the office's intersection with the public so as to make it conform with their personal, religious, or other beliefs," end quote. Dr. Janet Epp Buckingham disagrees.
Under our Charter of Rights and Freedoms, we have freedom of conscience and religion. And this should not stop, really, just because you are a public official.
Buckingham is a lawyer and professor who specializes in religious freedom. She says in Canada, there are many cases where a public official's religious beliefs are accommodated.
One example is a group of nurses who worked for a hospital in the obstetrics ward, and they were accommodated in not having to participate in abortions. And that was a very significant situation. Bus drivers in Toronto were not required to hand out transfers that advertised gay and lesbian organizations. Pharmacists who have a freedom of conscience and religion that is respected. And the RCMP has accommodated Sikhs wearing their turbans and not wearing the RCMP hat. Now, is that imposing their religion on everybody else? I don't think anybody really thinks that it is. It's accommodating their religious beliefs.
Justice Jean Ann Smith, in a second majority decision, wrote that the argument the commissioners were making could be made by, quote, those who sell marriage licenses or those who rent halls for marriage celebrations and disapprove on religious grounds of same-sex relationships, by those who provide rental living accommodations to married couples, and even those who provide restaurant meals or entertainment to the public. Buckingham argues that a slippery slope is unlikely, nor is it that simple.
We have general human rights codes in every province that deal with this kind of issue, that deal with discrimination amongst business owners or dealing with accommodation. There was a case in Toronto several years ago that dealt with a printer who did not want to provide printing services for a gay and lesbian organization called the Gay and Lesbian Archives. And that set out some parameters, some limits as to when business owners can discriminate against individuals or organizations based on their religious beliefs.
Though the Saskatchewan court rejected the option as unconstitutional, Faye Sonier says it's already being done in other provinces.
It was presented in the record before the court that, in evidence, that there are already 6 provinces and or territories that are currently accommodating marriage commissioners either in practice or in policy. So they already have a system in place where marriage commissioners can recuse themselves, or it's just sort of done ad hoc, behind the scenes.
Confused? Well, let me explain. In Canada, while the federal government is responsible for defining marriage, the provinces are responsible for the ceremony, which means all across the country, different provinces have different rules. Dr. Janet Epp Buckingham.
In Ontario, for example, it's judges and municipal clerks who are responsible for solemnizing civil marriages. Now, they all have other jobs. And when a same-sex couple or any couple wants to get a civil marriage, they would go to City Hall and they would kind of be assigned somebody. Whoever is assigning the judge or municipal clerk just wouldn't assign somebody who has a religious objection to same-sex marriage.
It's called a single entry point system, and it's used in Ontario and Quebec. Out west, however, things are a bit different, she says. Commissioners' names and numbers are publicly listed, and it's up to couples to find their own.
So because there's no in-between, no interface, nobody who is assigning people, it makes it a more difficult situation.
Ironically, in their decision, the Saskatchewan Court of Appeal brought up the single entry point system as a possible alternative. So why didn't the court adopt it? According to Faye Sonier, a lawyer who argued for accommodating the commissioners, it wasn't one of the options.
When the court discussed the single point entry system in its decision, it closed by saying, essentially in layman's terms, we're proposing it, but this isn't the place for us to do a constitutional test of this proposal. That needs to be done in another context.
And while the marriage commissioner's reference is over, Sonier says the fight for religious freedom in Saskatchewan isn't.
This isn't a closed case. This is just a reference. So all this is the court giving the government its opinion. Now, of course, it's of important value because we had 5 top judges in the province of Saskatchewan giving their opinion, but the government is still free to do what it would like.
Saskatchewan Justice Minister Don Morgan didn't respond to repeated requests for an interview. But in a statement on the Justice and Attorney General website, Morgan says the government of Saskatchewan won't appeal the court's decision. And while the case involves Christian marriage commissioners, both Faye Sonier and Janet Epp Buckingham agree. The court's decision sets a new precedent for people of any faith in the public sector.
Despite what the judge said, it's very clear that same-sex rights were a higher priority than religious freedom. And so I think any person of a significant religious faith would need to be concerned about this kind of case because it minimizes the freedom of conscience and religion for all religious believers.
In the meantime, Saskatchewan Marriage Commissioner Larry Bjerland is sticking to his guns. Although he wasn't available for comment, in a recent statement to the CBC, he said, quote, "I have no objection to gays getting married. My only objection is forcing me into doing it. I'm not going to resign. They'll have to fire me." For 100 Huntley Street, I'm Bridget Antwi.